Members of the jury, any action of this nature is predicated upon a claim that the defendant has been negligent because the law would not permit you to find a verdict for the plaintiff or to award any damages unless you should recognize that first, that the accident resulted because of negligence on the part of the defendant. Secondly, that there was no negligence by the minor plaintiff which contributed in any way to the accident. And thirdly, that the injuries and the death resulted from the accident itself. Negligence is a failure to use the care and caution which a reasonably prudent person would exercise under the same circumstances. The reason that the plaintiff cannot recover without proving negligence on the part of the defendant is that the law does not raise any presumption just because an accident has occurred that the defendant has been negligent. That is a matter which you would have to find from the testimony. On the other hand, the law holds that if a claim is predicated on behalf of anybody, thereby there can be no recovery if that particular person was himself in any degree responsible for the accident. That is what is called contributory negligence. If any negligence on the part of the minor plaintiff contributed to the happening of the accident, there could be no recovery. In this case, inasmuch as the minor plaintiff died as a result of the injuries, the law raises the presumption that he was careful and that he was not contributorily negligent. It would be essential, therefore, for the defendant to be negligent on the part of the boy. That will be one of the conditions you will have to take into consideration. It is your duty to determine the facts. It is your duty to reconcile the testimony as far as you can, hearing, or rather bearing in mind the fact that no two persons recount a thing exactly. Bear in mind the further fact that there is not to be any confusion on the part of witnesses inexperienced in court, discrepancies which may appear. You take all those factors into consideration and you bring to bear, in passing upon the facts, your judgment as to who has been telling you the truth. In other words, you pass upon the disability of the witness. Now, you may take into consideration their interest in the outcome of the case, if any. I do not mean that just because a person may inquire as to the outcome of a case, that he or she is not telling you the truth. That is merely a factor for you to consider. You bring to bear all those conditions that you have required or acquired as human beings, which enable you to determine whether a person is being truthful or untruthful. Although I shall refer to the facts, you take your recollection of at all times in preference to anything I say, and it may be that I will make some error inadvertently in discussing the four facts, or I may overrule something that you think is important. So you trust your own recollection. It is also your duty to determine what inferences flow from the facts that you think are established by the weight of credible evidence. Your verdict must be unanimous. You take your instructions as to the law from me, but you are the proper persons to determine just what happened in the particular case. You must arrive at your verdict without either prejudice or sympathy. You have absolutely no right to find a verdict against any defendant because you sympathize with the plaintiff. You would have no right to find any verdict because of prejudice or any feeling of that kind. You are, as briefly as I may put it, an impartial, fact-finding body, and you approach your duties as in an entirely dispassionate frame of mind. Section 9 of the National Labor Relations Act, as amended, provides that the board shall make no investigation nor issue any complaint on behalf of a union unless there is on file with the board a non-communist oath of each office of the union and of each office of any national or international national labor organization of which it is an affiliate or constituent unit. Okay.